Many of you have reached out to me asking me questions as it relates to a set of allegations regarding DA Fani Willis and attorney Nathan Wade relative to an alleged affair, romantic relationship, and perhaps some impropriety with funding coming from the DA's office. Now, as it stands right now, these are accusations and there's really nothing set in stone as it relates to proof, but we will find out on February 15th what is really going on. So instead of me trying to come to you with my thoughts about this, I figured I'd go to the person who would know. And that person is Attorney Gerald Griggs, who is also the state president of the Georgia chapter of the NAACP. So we sat down, we talked about the issues, and here it is. Once again, Attorney Griggs, we always are here trying to get the facts straight about what's going on in the community that we serve. This new set of situations with DA Fani Willis, it seems to be more about perception than it is a fact of law. And I just wanted to get your thoughts on this whole accusation. And I wanted you to tell us what's factual and what's not.
Well, first and foremost, we have to remember that all these allegations were made in a motions filing with no evidence of the allegations. So basically what's happening is Mr. Roman, who is charged in the RICO conspiracy to obstruct and interfere with the Georgia election, alleged that there was impropriety between DA Fani Willis and Special Prosecutor Nathan Wade, and believes that that should cause the dismissal of the indictment. So Judge McAfee is going to have to listen to the motion and see the evidence. And again, the preponderance of the evidence standard, the burden of proof will be on the defendant to prove, one, that these allegations are indeed true, and two, they have some sort of effect on the underlying criminal indictment that was filed against him by Fulton County through the Fulton County DA's office and the grand jury. So I think right now it's much ado about nothing. We don't know if these factual allegations are true. And if they are true, it would amount to a lapse of judgment by the district attorney and may cause an ethics probe from the county and potentially some type of ethics violation. But I don't think it would rise to the level of the dismissal of a criminal indictment on facts that have nothing to do with the underlying probable cause for the charges. So there's a lot of substance that's lacking right now and proof that's lacking. Judge McAfee has set a hearing for this where the defense is going to have to put forward evidence to substantiate these allegations. And I would really caution the public from jumping to any conclusions until there's actually proof. And the fact that the GBI has already come out and said they're not investigating this shows that this really has nothing to do with the underlying criminal allegations in an indictment that has been brought forth by the citizens of Georgia, showing that there's probable cause that a RICO conspiracy occurred. You know, whatever happened in Madam DA's personal life is just that, personal. It may be, if proven, a moral lapse or ethical lapse, but as far as the criminal indictment that is against these individuals, it has nothing to do with it.
It's very interesting you talk about perhaps a lapse in judgment, because as you know, and I know, DA Fani Willis is very intelligent. She's brilliant in the courtroom.
Yes.
And so I would think that at some point they knew that this was out there and they knew that there was a possibility that this would come forward. What I found interesting is the way that DA Fani Willis responded recently. I saw some information where the ex-wife or whatever she's called right now, I'm not sure if she's an ex, I'm not sure if the divorce went through, but Nathan Wade's ex, the reason why this divorce happened in the first place was as a result of an adulterous situation that she had with attorney Nathan Wade's best friend. And that's what caused this whole divorce proceeding to happen some 2 years ago. So in my mind, I believe that a person has the right to date whomever they want to date. And I think it's getting conflated where, let's just say there is some sort of impropriety as it relates to their personal relationship, which I don't see. Like you said, it still doesn't negate the fact that there are charges that are current, there are charges that are factual, that still the DA's office has the ability and the right to move forward.
Well, I mean, ultimately, it comes down to what proof you can provide. And so when an indictment is brought forth, the onus is on the prosecutor to prove every material allegation in the indictment. So if some charges in the indictment they can't prove beyond a reasonable doubt, the jury can acquit, the judge on directed verdict motion can dismiss. So again, you have to prove everything. But with regard to these allegations that are brought in a motion to dismiss the indictment, there does not seem to be a factual basis under the law if these allegations are proven to be true for the judge to even entertain this. So there may be some issues that people have not brought up yet. You know, you're not supposed to file a motion that potentially could be frivolous. So that's where the rules of professional responsibility and ethics as a member of the bar, you don't go down this road with potential salacious information that deals with somebody's private life that has nothing to do with their job. You don't typically file those. So it's very rare you see anything like this. I mean, would you imagine in a basic criminal case that somebody would make an allegation that the DA is having an extramarital affair? I mean, what does that have to do with whether or not the person who's charged with the crime is or in fact innocent or guilty? So I think we're going down a road here, and we have to recognize that certain defendants in this trial are known for their circus-like atmosphere around anything they do. In a court of law, it's not supposed to be a three-ring circus. There are rules of evidence. There are rules of procedure. I think Judge McAfee, he is a very learned jurist. He's going to follow the evidence. And if there's not the ability to, one, prove these allegations, and then two, tie them to the actual charges, there may be lawyers that may be in trouble for filing something like this. I think the response from Madam District Attorney was apropos in that, you know, she gave her statement at Big Bethel AME. She also responded in both the divorce proceedings and the criminal proceedings with her legal analysis on this. I'm looking forward to hearing the defense's side with their case law and statute-based argument coupled with the proof of these factual allegations to see, you know, what we can do in the law. But I think that this is a stain on our process. You know, many of us have gone through issues in our personal life that you don't want brought into a courtroom that have nothing to do with the practice of law or your professionalism. So I just think that we're going down a road that I think every lawyer needs to be very cautious. Yes, your client may want you to file a motion, but you need to have a basis in law to argue that this motion is, one, relevant, and two, has some basis to overturn the indictment. So it's just curious to watch all of this as a litigator to see where this is going. We've seen lawyers who have represented individuals in this particular RICO case, not in this case, so to speak, but in other matters, be disbarred for things they said in court, things they did in court. Let's be clear. The courtroom is a very serious place. It's a place where people's lives are on the line. These defendants have a right to due process. They have a right to have their day in court, have an indictment that is perfect, that lays out the allegations so they can know what the allegations are. But here's the problem that they face. Even if you can prove that these allegations are true, and you can prove somehow it's tied to the indictment, the remedy for this is the dismissal of the indictment, but you get another shot to bring another indictment within 6 months. Or if they can prove a disqualification of the district attorney's office, the only thing that would happen is one of the other 58 DA's offices in Georgia would take over the case and the case would continue. So it would not bring an end to the case. It would just take this particular district attorney's office off the case. And as a professional, what you have to realize is now that you've made these type of allegations against a sitting district attorney, don't you think the other sitting district attorneys will look at what you've done and come with all guns blazing? Because there's a small legal community here in Georgia. We all have levels of professionalism we want to maintain. We cannot allow the three-ring circus to come to the judiciary in this state.
Let's say that they went on his vacation or several vacations, and he spent his personal money to pay for these trips. And he invited her and she went. I believe that they're trying to say that the money that he was paid by the district attorney's office is what causes the financial aspect of this is illegal. He cannot use money given to him by the DA's office to use for private matters. What say you?
What I say is I don't see a crime there. I mean, what are we saying? Theft by deception, theft by conversion? Did he do the job that he was paid to do with regard to his investigation in this Trump matter? So far, it looks like, yes, he's being paid to do this job, to represent them in court. So what is the conspiracy or the crime under the Georgia code? If anything, it may be an ethical issue of whether or not there was a conflict of interest. But then what's the conflict? So I see how we are going down a rabbit hole where there appears to be smoke there, but is the smoke going to lead to a fire that invalidates the indictment? I think that's a leap. That's a stretch. And so I just think that at this point, there are two things that need to happen. One, in the divorce proceeding, there needs to be evidence taken that shows whatever is the allegation with regard to the divorce proceeding. And again, divorce matters can get real ugly real fast. And then in the criminal matter, there needs to be a motions hearing with evidence. Again, people will jump into conclusions. There's no evidence right now. There's innuendo, there's speculation. No witness has been sworn, no document has been entered into court that shows, one, that there's actually a relationship, two, it has any bearing on whatever is happening in a courtroom in Fulton County, and three, there's a connection that leads to a criminal act or a ethical violation that would disqualify anybody. These are leaps. And the biggest thing people need to be concerned about is this. What happens in a motion hearing? And 80% of the motions that are filed in criminal matters are dismissed. What happens if that motion is dismissed? At that point, if it's not able to be proven, there's a such thing in the law here in Georgia as defamation and slander. So we're in a public conversation, assuming that facts have already been proven that have not been proven and may or may not have some bearing on whether or not there's some illicit relationship. I think we should the cooler heads should prevail. I think that everyone should wait to this motion hearing, wait to the end of the divorce proceeding, and see if there's any there. But the fact that the Georgia Bureau of Investigation has already said they have not opened any criminal probe into anyone says where we are legally in the state of Georgia with regard to any conspiracy or any violation. I do know the Fulton County Commission is launching an investigation into whether or not there was misuse of funds. They need to do that just to make sure that everything has been covered. But I don't know if this really goes anywhere past the hearing that Judge McAfee will be having very soon.
The other issue seems to be Attorney Nathan Wade's qualifications. He's
Yes.
not qualified to work on a RICO case. He's never, he's never done anything regarding a RICO case, but he was a judge. He has a very stellar record as it relates to the legal community. What say you again as it relates to his qualifications and his level of professionalism as it relates to the legal system?
And see, this is where you have people commenting on the legal system in Georgia who have no idea what the legal system in Georgia looks like. Nathan Wade is one of the most seasoned criminal defense attorneys in this state. He's got well over 25 years of practice. Just because he's never prosecuted a RICO conspiracy does not mean he has not dealt with a RICO conspiracy. I believe in his career, he's handled RICO cases on the other side of the V. The key to being a litigator in Georgia is to understand how to be on both sides. And in a RICO conspiracy this complex, don't you think you would want to have one of the best RICO experts in the country, Mr. John Floyd, and then two, a cadre of very versed criminal litigators who have been prosecutors that Miss Willis has in her office, and then two, and most importantly, a seasoned criminal defense attorney so that you can fill up all the holes and there's no reasonable doubt. That is a dream team. So for people to sit there and say, oh, he's never prosecuted a RICO case, that's not his job. His job is to manage the team to make sure that there are no holes that get an acquittal. And so I think it was very astute for Ms. Willis to pick a criminal defense attorney who has the skill and the notoriety of Nathan Wade to help join her team. It would be similar to, I don't know, hiring a 20-year veteran who's tried on the other side, Georgia's longest RICO case, and decide, you know what, I might need a defense attorney on my side to come up with the ideas that the other side may bring so I can make sure I don't have any issues with my case. It was a brilliant move. My hat's off to her for doing it. And I think that people are missing the fact that just because you've not been a prosecutor does not mean you're not a criminal litigator. There are two types of criminal litigators, prosecutors and defense attorneys. And no one has gone through and said, Nathan Wade, one, hasn't tried a case, two, hasn't won a case, and three, has been practicing in Georgia for over 25 years. So I think people need to pump the brakes a little bit and realize that this is the most complex RICO case that we've seen in Georgia. And you want to have all opinions and all thought processes in your prosecution.
Another issue seems to be, and when I say issue, when Fani Willis, or DA Fani Willis, was looking to put this dream team together, she solicited a lot of different attorneys, and most of the well-known attorneys that handle RICO cases were either not available or didn't want to do it because of the rate. The DA's office at this moment was only able to pay $250 an hour. And from my understanding, the average rate is somewhere between $500 to $600 an hour, which is a considerable drop for somebody who's very busy and needs to take away a year of their life to do a case like this. So again, you being an attorney, tell us what your thought process is as it relates to just the financial aspect of this case.
Yeah, and I mean, that's one of the things people need to look at. You know, when you take a case like this that could last 2, 3, 4, 5 years just investigating it, and then a year to 18 months or 2 years when you're looking at YSL to actually litigate it, it's going to cost north of $500, $600, $700, $800 an hour for you to be able to maintain your practice, but dedicate a year and a half, 2 years for this one case. And so I think, Attorney Wade did discount his price. Any 25-year veteran lawyer is not going to be charged at $250 to $250 an hour. That's a little low. And to have the level of expertise, there were only maybe a handful of lawyers that could take a case like this, and many of them are in the YSL case. So for a lawyer on the defense side, who's not a prosecutor, who has RICO experience to bring to the prosecution of this case, ideas that they may not think. There's a short list, and many of them have already said, either one, I'm not taking any more RICO cases that last 18 months, 24 months. Two, I'm already in one of the biggest RICO cases in Georgia that's still going on, the longest case in Georgia. And three, they don't want to deal with the sideshow that comes along with that. People having to make sure that, their home is protected and they don't get doxxed and all this other stuff that's going on with this sideshow. I think that it was a great pick. I think that he wanted to do his service to his community, particularly the African Americans who may or may not have been the subject of massive voter intimidation and intrusion, and ultimately the potential of the attempt to invalidate their votes. So I think it was a decision he made to try to help his community. And I think it's something that a lot of lawyers were not available to do simply because of finances.
My last question. There are a lot of issues regarding this case, as you know. There's all kinds of things happening to attorneys and everybody else associated with it. Is there any way, and I know you said that it's a leap for this to be dismissed, but if that were to happen, is there any way that the people who are already pleaded guilty for those cases to be reversed, or any of the people who have plea deals in the makings, would any of those deals be deemed invalid because of a dismissal of this particular case?
If they could show that something improper happened with the presentment and the investigation and ultimately the return of the indictment, then yes, there probably could be some attempts to invalidate pleas or reverse convictions. But I don't see that happening based on the information that is available publicly right now. I think worst case scenario, the Fulton County District Attorney's Office would be disqualified. They would reappoint a special prosecutor to take over. That would be one of the other, 59 DA's offices throughout the state, and the case will continue. Now, it would take some time for them to get up to speed on the case, so it may delay it past the election. But I don't see the indictment being dismissed on this ground. There may be other arguments for the indictment to be dismissed. And if the indictment is dismissed, they get another bite at the apple for an indictment. You have to have 2 subsequent no bills for a case to be over. So I think that it's an interesting conversation in the public. It's an interesting law school debate and ultimately analysis. But I think at the end of the day, this case proceeds forward. And I think that lawyers and defendants need to be very careful when dealing with a very angry and very focused Fani Willis.
Yeah, I don't know why one would want to pick a fight with somebody as capable as DA Fani Willis, because she's shown what she's made of. Whether you like her or not, she's very capable in that courtroom, and her results, speak to what she can do. And especially if she's motivated, to set the record straight. So
yes. And one thing that I think that, the lawyers, because let's be clear, most of the lawyers that are in this case have not tried a RICO case in Fulton County. They need to understand that a Fulton County jury is very astute and educated, and they're watching everything that's going on right now. I don't think that anybody's made up their mind with regard to the underlying merits of this case, but they are watching the circus that's going on. Yep. And I think that the lawyers need to understand that they're not playing to a jury of 1. They're playing to a jury of 800,000 people who were very concerned about the attempt to overthrow their vote in 2020. And so you need to try your case in a courtroom. I know there are people who are used to trying their case in the court of public opinion.
Right.
And that could very well happen.
Yeah.
but you need to try your case in a courtroom, and you need to be focused on what those 12 citizens are going to say. Because if you are unsuccessful in convincing 12 citizens, it's going to be a lot of people spending a lot of time in the Department of Corrections in Georgia. And that is not a place that you want to be.
Well, February 15th is the trial date or court date for this particular proceeding. And of course, we're going to be on it. I know you will as well. I'm very anxious to see how this turns out. So I appreciate your time. Know a lot of football games is happening at the moment, but we're going to get back to that. But I appreciate you taking out the time, like always, to speak to us.
Well, I appreciate you having me on. As you can see, I'm completely in football mode. That's why I got the T-shirt on. Playoffs are happening right now. And I just thank you for opening the platform. I think we need to have more informed conversations on what's happening in real time. A lot of platforms are just going with the salacious nature of this and not doing a thorough legal analysis of where this is going to go. So I'm happy to provide that, and I'm happy for you having me on the platform. Look forward to coming back on.
Well, we appreciate the clarity. And as you said, it's needed. And the reason why I decided to do this is because a lot of people hit me asking me for what I think is going to happen. And I'm not an attorney. Of course, I'm in the media and I see things just like you do. But from a legal basis, I can't really tell people anything other than to say, let me talk to my man who I know would know. And let's get something out there that makes sense and get some clarity, because there's a lot of misinformation happening right now.
Absolutely. And I think what people also need to understand is, the legal community talks. So when the motion was first filed, when we're in jury boxes, preparing and calendar call, lawyers are talking in Georgia. And, I keep my thumb on the pulse of the lawyers, and most of them are saying the same thing. Interesting motion. It won't go anywhere to be dismissed, and y'all don't want to have to deal with a pissed off Fani.
There it is, right there. I mean, that's just real talk. And you could tell when she was at Big Bethel, she was obviously very irritated with this. And as well as I do, because we've been covering her for years, she does what she does. And this might not end up good for a lot of people involved, as you noted.
Yeah. I think that, whatever plea deals were available just went away. And, when you get into this line of work, understanding the grave nature of this process, nobody's going to leave their professionalism at the door and operate off emotions. But when you attack somebody like this, it leaves any room to negotiate at that point. When I listened to what she said about the death threats from to her daughters, to her, to having to realize, and be open publicly that she's not a perfect person. Why does somebody have to do all of that just to practice law? We're talking about practicing law. We're talking about making sure that the Constitution of the state of Georgia and the Constitution of the United States are protected. And these are some very serious allegations against the defendants that goes to the crux of our democracy. So let's be clear. I'm taking my lawyer hat off for a moment. I'm just being a Georgia citizen. I don't care what the prosecutor and one of her people that's working on her case are doing. All I care about is whether or not somebody tried to find 11,000 votes and invalidate an election in Georgia. If that happened, somebody going to prison for a long time. So the antics need to stop. If there is a legal issue with the indictment, say that. The indictment is flawed, fatally flawed, because it doesn't make out a crime. The indictment was procured through processes that were not the normal process. There wasn't a thorough investigation. Those are all fair game. But going into people's personal lives about whether or not they are, in fact, doing something, what's good for the goose is good for the gander. I'm sure lawyers don't want motions to be filed against them saying they are doing things that they are not supposed to be doing with people. It's just not a good look. So I think that moving forward, after this motion is addressed, there needs to be continuing legal education about what is and is not fair game in a motion in a criminal matter.
Well, you said it best. This has become a circus. It's no longer, and it's unfortunate, the courtroom is doesn't seem to be for certain people a courtroom. It's a tent with circus atmosphere to it, and it's quite unfortunate, to say the least.
Yeah.
My brother, thank you again. We'll get back to football, and we'll wrap this up on the 15th or whenever we get some clarity on what's happening with this case.
I appreciate you, brother. You have a good evening. I'm going back to watching football.
Yes, sir.